Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess who's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey guys, it's Squid. Welcome back to the channel. Hope everybody is doing well on this Friday afternoon. I need as much caffeine as possible. So if anybody wants to get in touch with Celsius to sponsor me, dude, um, I live off of these things. Hope everybody is doing well today. Cynthia, please tap the like button on the way in. Thank you. Thanks for doing your Modly stuff. And Ongkong Hero, you as well. And thank you, as always, for turning the chat green with your 10 Squid Pro Quo memberships. I appreciate you so very, very much. You have absolutely no idea. Hey, Janet. Hello, Squid and everyone. I'm having a good day. Deep cleaned my kitchen while listening to Spawn Trooper. Now I get to listen to Squid while doing laundry. Well, yeah, I hope I can help you fold that laundry with energy. I usually don't have this much energy, and I'm not gonna lie, I was supposed to get up and go to the gym this morning, but I went up and I texted my friend that was supposed to go with me, and her son totaled his truck last night. He is fine, but she was not able to go, and I was just too comfortable, and everything just hurt when I moved, that it was like, no, I'm gonna stay right here. So I started to listen to Spawn, and then I passed back out, and I got some extra baby squid snuggles this morning. Nose picker, how are you? Oh my god, I love the name change. And Hill on top, going to try and hang out, but maybe busy. This is a wild story about the judge. Yeah, and I've covered this in the past. I haven't talked about this topic in a while because honestly, there has been not a lot of information. Kentucky is not easy to get documents from. They don't make a lot of things public. They're not like Florida. Most states, you have to dig, you have to call people, and I don't people very well. So trying to call up or find somebody in Kentucky who's willing to drive out to the Letcher County courthouse and get all these documents for me is just meh. However, there is a hearing today that is live. We are waiting for it to start. I have it up, and whenever it starts. However, there was a document that I was able to find. This is from back in March. And hey, Mal, and hey, Alley Cat, and hey, John Thunder. How are you guys? Here's the thing about this case. It was on video. And then we watched a little bit of his the body cam footage, um, and it was just off. Then I read some of the lawsuit of why there might be an issue with there was an issue between the judge and the uh, the sheriff. None of this is adding up. We don't exactly know. It seems like every time you find out more information, all it does is make you ask more questions. And hey, Rickles, how are you? But I did manage to find a document from back in March. Oh, the little's having a meltdown. Oh my goodness. That my poor baby. Um, we are going to go over really quick before this hearing starts at 1:00. But it is a notice pursuant to RCR 8.07, support for participation of defense expert in any state requested examination. This has to do with the competency of Mickey Stines, because when he was in the back of that squad car going to not the Letcher County jail, but another county, he was saying some things that didn't quite, and he was acting very not in his right mind. I'm not a psychologist, not a psychiatrist. I'm not diagnosing, but I've talked to enough people with mental health issues to know when something's off. And he just did not sound like a normal, well-adjusted, in his right state of mind kind of person. So we are going to get into this super quick before we, and I just had to go to the right tab so that I can keep tabs on the, I can keep tabs on this. Because Court TV has a trailer playing and it's like, you know. But while we are waiting for the hearing to start, we will read through this document. And this was filed back in March. I just got my hands on it in July. However, I haven't read it because nothing really has taken hold in this case, and there's been no updates. So it's kind of been like, yeah, I haven't been interested in reading it. However, comes now defendant Shawn Mickey Stines, by and through counsel, hereby states, notice pursuant RCR 8.07, defendant intends to present an expert evidence relating to a mental disease or defect or mental condition bearing on the issue of guilt and punishment. Defendant intends to present a defense of insanity as well as a defense of extreme emotional disturbance. The undersigned counsel does not raise the issue of competency to stand trial, support for attendance of expert in the event that the Commonwealth elects to request an examination under RCR 8.07, then the defendant is entitled to participation of an expert in the Commonwealth's examination that is not only permissible but mandatory upon request. KRS 5.0 or 504.080 provides that an examiner retained by the defendant shall be permitted to participate in any examination under this chapter. And I'm not sure what all these statutes say. Obviously, these are Kentucky statutes, so not exactly sure what they're saying. They are showing the inside of the courtroom, but the judge has not come in yet. So once he comes in, we will be switching over. KRS Chapter 504 governs the examinations for both incompetency to stand trial and insanity. In McCracken County Fiscal Court v. Graves, Kentucky 1994, the Kentucky Supreme Court addressed the mandatory nature of the statutory right in finding that costs associated with the defense expert's attendance during the state's examination were reasonable. The McCracken Court held, in view of this statute, we believe that whether a defendant avails himself of this opportunity is strictly a matter of legal strategy to be decided by a defendant and his counsel. It is not a question for the defense expert to decide. Nor is it a question for the trial court. The statute not only permits the defense expert to be present, but it mandates that the expert's presence be allowed. And I'm going to switch over to the court, but I will continue to read this. That way we don't miss a thing. Come on. There we go. And obviously I got to make this bigger because, there we go. All right. I will continue to read this and then turn on the sound when the opportunity arises. In this case, Dr. Johnson was present at the defendant's interview with Dr. Skelton as provided by the statute. Evidently, the legislature envisioned circumstances in which a defense expert's presence at an interview with an opposing expert is important enough to provide for in the law. We are unwilling to uphold the trial judge's ruling that defendants availing himself to what law provides in the interest is not a necessary expense. Wherefore, defendant respectfully submits the foregoing notice and support for attendance of the expert pursuant to statute, as well as the order of this honorable court. And that was signed by his lawyer, Jeremy Bartley. So basically, all of that is to show that he is going to present an expert relating to his mental disease or defect. So it's not that he's incompetent to stand trial. It's just that he was insane at the time. So we shall see how that goes over. What the judge has to say about it. Wait, what happened to 1 p.m. here? I thought I was a few minutes early. So I was originally going to stream the What the Hales judge's motion at 1 o'clock. However, I found out that this was going to be a live hearing, and I've been covering this case since back in September when it happened. I haven't done an update on it in a while because there really hasn't been anything to come out. And then I found out that there was a live hearing. So I moved that back to either 3 or 3:15. That way, after this is done, I can take a break, get something to eat, hang out with the fam, do what I need to do, take a potty break, and come back. So you're not late for the other one. Oh, and in that other stream, I do have a special surprise for people with a certain person that has been evading service that we've seen a lot of body cam footage of and affidavits by the process server and all of that from Jeremy's side. Some of you know that he is a convicted felon who did a year in prison for reptile trafficking. Well, I have that case. And I have not only the indictment and all the documents, but I have all the transcripts. So we are getting together for something new. I don't know when it's going to be. I have to talk to a bunch of people because I have to coordinate things. That's the hard part about streaming with a bunch of other people, is you have to coordinate times and schedules and things that it's not necessary for me to do when I'm streaming by myself. So I asked a few people if they wanted to hang out with me and do some dramatic readings of some trial transcripts. So we will read not only his indictment this afternoon, but there will be readings of Dodgy Robbie's federal trial in the Eastern District of Pennsylvania, I believe, about everything that he did wrong to end up in jail and why he only got 12 months and his co-conspirator got 18 months. Has he always been a bitch? Oh, yeah. That's Judge Spawn. So, and there is Shawn Stines, also known as... And he was the former sheriff of Letcher County, Kentucky. There has been rumors that his daughter was involved. There was issues with there was another lawsuit that he was being sued for, that he didn't handle some training or some things right, where someone was SA'd. It's yeah, yeah. He what what had to happen where he decided he wanted to he go from the sheriff of the county to a convicted or in you know. So we shall see how this goes. But I have been waiting for this for uh somebody is lurking and keeps sending me messages, but that person's supposed to be working right now, so get your ass back to work. And as far as I know, this is in the Letcher County Courthouse, the exact courthouse
All right.
where he unalived the judge on camera.
Be seated and let the court come to order.
And anybody who's followed court cases, you know courtroom audio sucks. So
24 CR 204, Alabama, Kentucky versus Shawn Stines. My name is Chris Worrell, I'm the special judge appointed in this matter. I will identify themselves and everybody counts the paper.
Jackie still have color paper.
Ramsey Allen on behalf of the county. Governor Kerry Bartley on behalf of Shawn Stines.
Good Your Honor, Jeremy Bartley on behalf of the distributing staff.
All right, thank you. I see Mr. Stines is present. The court set this matter today for the status hearing to address a few matters. I think we're in such a position now where we will be able to set some upcoming court dates to get this matter proceeding forward. We have been waiting on a KCPC evaluation to be done on the defendant. That has been completed. It is currently under seal. His procedure is done standard in any type of case such as this. That matter right now is under seal. There's been a motion for the KCPC evaluation to be unsealed. Mr. Bartley, that's the main purpose for that is you wish to, if the court does that, and then the hearing and the other two motions, you wish to have that as potentially used.
That's correct, Your Honor. Our intention is to have it for the purpose of those evidentiary hearings. I believe that it contains, without speaking about what it contains specifically, Judge, I believe that it does contain valuable information that the court would be able to use, particularly in the bond hearing in terms of coming to making the court's findings that are necessary to determine whether this is a candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right. And Mr. Steele, how long, you don't have to respond to that in regards to that yet. How long do you want to have?
Judge, you give us 10 days. I think we got it last week, so if you give us 10 days to respond to that motion. That's it. Thank you.
All right. What I would like to do though is at least see how far we can get without addressing beginning KCPC evaluation issue. And the fact so the court has read that, so keeping that in mind, but we can address first the motion to dismiss the indictment.
Your Honor, I will.
Good.
Choose what would have to do, Your Honor. Your Honor, we filed a motion to dismiss on 2 grounds. Number one, under RCR 5.16, failure to provide or to add a transcript of the grand jury proceeding. As court knows, RCR 5.16 requires that the testimony taken in front of the grand jury must in fact be recorded. Now, it kind of came surreptitiously, we were listening to listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury, can I speak to the content of the grand jury aside from what I think?
Yeah, and for purpose of record, the court has been provided a transcript, a CD recording of that we used for the
Thank you. So there's a reference to one of the grand juries that said in our last meeting, or in our previous meeting, and I'm paraphrasing it. And so at that point, we weren't aware of the previous grand jury hearing. And so I inquired of the Commonwealth. They did respond to me. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records. And the judge anticipated a response. But I guess, what's odd about that to me is that I've done thousands of grand jury hearings, and if you want evidence brought to a grand jury, you usually submit it back to the hearing. I mean, there's no reason you don't have permission for the grand jury to subpoena. You send a subpoena, you subpoena the custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that is what was going on, and I don't know, there's no recording, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury. Hey, this is this case, this is what we know. And I think the Commonwealth was making a distinction that, well, if you don't come in and raise your right hand and swear, it's not testimony. Well, actually, the distinction is sworn testimony and unsworn testimony. I'd submit to you that the only way you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense, that you have to tell them something. They don't walk into the grand jury room and say, just look at each other, and the grand jury says, hey, we'd like a correct subpoena. Now, I will say this, I do agree with the Commonwealth in their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, if you to ask for or form their basis for asking for medical records, Judge, I think that should have been recorded, so we would have that available. And I think 5.6 requires it, and the remedy is that complaint shall form a motion to dismiss. I can address the other area, Judge. Okay. And the second area, Judge, I really think, Kendra, that may need an evidentiary hearing. It may not. I mean, I'm not sure. Well, I'll leave that to the Commonwealth as to the response to that. But in terms of the other portion,
you're talking about the statements made during the presentation.
yes, sir. As to the second portion of my motion, it's based upon Commonwealth feedback here, and Mr. Cox actually handled Mr. Baker in that case. We all know the prosecutor's community is the aluminum back case. The detective goes in and testifies and says, basically it was aluminum back used, this one used aluminum back. In reality, it was a wooden stick or something. And in that case, following conviction and appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you get misleading. The bigger debate really seems to be after that, is it rise to prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that falls into the without you representing the grand jury. And so when I look at, the grand jury transcript, Judge, and without getting into the case of the report, one of the really things that one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health of Mr. Stines. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation is young, and the answer is yes. That's Detective Stanford testifying that. Now, first of all, probably not an appropriate thing for Mr. Stanford, Detective Stanford, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't have died this case. Or at least they might not have died on murder. And so what I think, Judge, is that even if the court didn't find that this arises to the level where this case should be dismissed with prejudice, which is what we would ask, at the very least, I think this thing should be remanded back. It's sent back to the grand jury and let them hear the correct evidence. If that statement would be corrected, or at least take it out. I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that it's a, they can let somebody opine to what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. That's a pretty risky thing. And here, the investigation, it definitely didn't show anything. And there's other additional issues, Judge, and that's one of the things we want to have that evidentiary hearing for, is to ask about all of these statements and what the detective had in terms of the investigation. We want to put that on the court to show why we believe that was missing, in addition to anything else.
And I would agree, you require bad faith.
Yeah, I mean, Judge, I think that in the 9 Baker case, they said it was reckless. I mean, it's basically, and I think it's, and I do think it's at least reckless. But I think we need to hear more about what Detective Stanford knew. What he knows now doesn't matter. I get that, it's irrelevant, right? But what he knew the day he testified is very relevant. And I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him. And then, Your Honor, there are additional items that I think are also of concern. There's a question. I cited those, Judge, and those are additional items. If the court doesn't want me to go about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stanford. If you knew these things, why did you answer this misleading way? And I think it's right. I said, best, and I don't know. We need to hear you find out. That's what I answered. Unless the court wants to certainly take an issue and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, we would ask you to put on.
Sure.
Thanks.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. We would ask that the court to dismiss the motion, to deny the motion to dismiss the Here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time, there was no witness, there was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded. Myself and Mr. Steele. Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth. And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented at this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time the testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth's response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation. I'm sorry, Your Honor.
You as actually court representing that was a request made.
Yes, Your
There
Honor.
was no verifiable commentary or anything.
No, Your Honor. Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Just a point of clarification, if I understand your question. As you can imagine, nobody in the grand jury room needed to be told what case this was, or anything regarding the facts. So when we went in and we said, we're the special prosecutors in this case, we're here just so we can get a grand jury subpoena for mental health records. They began asking questions, of which we did not have an answer to. We never answered any subsequent questions other than that. That's something we're looking at. That's part of the investigation. Those matters be presented against you later. There was never, of course, at this point in time, the preliminary hearing argument had, the video was already out. Other videos had been released. There was nothing we added at all to or any conversation regarding the case other than the investigation and why we needed the records. That would have been it.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested as far as the grand jury subpoena in writing, which was offered by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery packet. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as the Jackson case. However, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the response. All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stanford testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation.
Okay, I just have to pause right here because just in case you haven't figured it out, just like Massachusetts, Kentucky is a commonwealth and have different sets of rules for different things, and shit up there is just wonky. No offense to my Kentucky viewers, I used to live there. It's insane.
Additionally, the rules of evidence, particularly Rule 1101, does not, which says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial, but it's not 10.
Usually grand jury proceedings for 30 minutes.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the purposes of the two. You know, hearsay is presented routinely in grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely in grand jury. These are commonplace and they are permitted under the law.
You would agree that you can't intentionally mislead.
Absolutely, Your Honor, certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpires when testimony was presented to the grand jury in November is captured on that grand jury report. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording, Your Honor. And so we do not believe that an evidentiary hearing is required. Or is required, sorry, Your Honor.
Is this her
So, Your
first
Honor,
time?
again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleading submitted as well, Your Honor.
Let me have just briefly reply. Yeah, just so I mean,
And unfortunately, I think that the judge is going to deny this motion. He was on video. Like, you can't, somebody has to be held accountable for that, and it has to be some pretty serious prosecutorial misconduct in order for the judge to not, or judge to completely dismiss this with prejudice. However, we shall see what happens, because we saw what happened to Alec Baldwin out in New Mexico. So just because you unalive somebody on camera doesn't necessarily mean that you're not going to get away with it.
I mean, I said it to the meeting judge. I understand we're talking about rules evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting. Oh, I get that, Judge, but my point is this: if you put that into context with what they let testify, then I think ultimately, Judge, what put on that evidence will show you that this grand jury was misled. I mean, the state alone, to be honest with you, the state alone, rendering opinion on standing is, in terms of, I get you don't have to be an expert judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should be admissible or not. I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but it's germane, it's their grand jury. It's not calling it their speech. They're the investigative body. And so the reason I cited two things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were retained. And that's why we're asking for the.
I should have talked about 20,000 cases we presented for grand jury.
Sure.
I would listen to the recording.
In your Honor, if the Commonwealth, thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat versus a wooden stick. I don't think there's nothing even alleged in the plea, even if you take everything in the pleadings that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of the grand jury. That hasn't been raised since, has been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
All right, I'll get an order on that. Well, if I need to hold on that bitch hearing, if not, I will hopefully we should. After the got to see the last one for place that under seal of conclusion of the hearing, and then take a copy of his name to review the person.
Yes, sir.
All right, next we'll go to Barney.
Yes, Your Honor. Again, Gary Bartley for Shawn Stines, Judge. And we filed our motion for the court to, it's been back quite a ways now that we filed that, but we did ask the court to kind of hold
It's
off.
not a, and I know that's simple things.
I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We have some witnesses lined up. And I think it'll be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a heck of an argument on bond.
What would be your proposed bond, like
Yes.
circumstance?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash or property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
Absolutely.
any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms
I'm
of his
gonna stop it
pretrial
for a second.
service.
Pretrial risk assessment, with all candor to all parties,
Sure.
is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that case of peace to the court. I think that when we are able to show the court what's in there versus, all of the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
Has to be
understand,
something else, right? We can't just look at the charge defense.
but that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, Again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, what we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, just because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went into a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already up at the Supreme Court issued last year. I gave you the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones.
And Spire, I saw it. Thank you for the $2 super chat. I just had to wait for a stopping place because this is live. So, and Hazel Monty Engel, thanks for the 10 pounds. Happy weekend. I do struggle to catch most of your live streams due to the time difference, but I do enjoy them when I can. Keep it up. I value your neutrality on majority of the topics. I have my moments. Things get a little iffy sometimes. Sorry, I hate headphones. They mess up my ears, but this is the only way that I can hear this. I can hear this hearing appropriately. Maybe now it's different, but like my brain and my nerve issues cannot handle headphones for more than like 10 minutes at a time. And Spire, yeah, Hun can't stay at 1:30 a.m. I love to you all. And I saw it. I apologize for not getting to it. It's just with this being live, it's hard to find an appropriate stopping place. And I also, with headphones in, can't judge how loud I'm talking. And I tend to get, which drives Mr. Squid up a wall. He thinks I'm already annoying with YouTube. So, and Mspire, thanks for the $2 Australian super chat. Can you see this? I sent free 7-month super chat. Yeah, and you've been a member for 7 months. Like, damn. I can't believe that I've had members for almost a year now. Like, what the hell? Like, I couldn't do this without any of y'all. I appreciate you so much. And let's get back to this live. just me being petty, does this prosecutor own a hairbrush? Because she's a little wild and crazy. I don't think that he's gonna get bond. It's been too long. I think the judge already has his mind made up. He just has to wait for everybody to stop talking so he can let everybody know. I would like to see an evidentiary hearing though, because everybody's been so tight-lipped on this case. There has been some things that I've heard, some rumors as to why he might have done this, but Kentucky's real closed off with the documents. It's very hard to get them. They're not easily available on any website, especially in rural counties. It's even harder. Bigger cities are easier because more technology, more people, more resources, stuff like that. But this is a very rural county, so it's a little, yeah. Also, it's not Florida, so everything's easier in Florida. But we'll get back into this. Come on, technology, work.
And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here in the preliminary hearing.
Right.
It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to that.
No, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to be able to introduce that.
All right. Thank you. Any response?
Judge, I believe the case law cited speaks right to the issue.
All right.
He does not.
All right. As with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah.
Yes, Your Honor.
Why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm going to try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, sure.
for all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday since today's kind of
Yeah,
shot next
10
week?
days from- why don't we do this? 2 weeks from today.
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather,
your motions.
I'd rather under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
Your Honor.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. And just to make the parties aware of talk those in chambers, we are looking for an expert on this issue. And
Sure.
and there's plenty chance we have to go through depending on what those come back as for an expert also. So we made council aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
Nothing
No,
more
Your
to come.
All right, ladies and gentlemen, pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be clear. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, sir. Thank you, Your Honor. Would like to.
What's that?
Yes, Your Honor. We wanted to talk to him for just a minute.
Yeah, absolutely.
Take care. All rise.
Thank you.
All right, so Inspector Guy, the defendant was the sheriff or deputy that shot the judge who was screwing his daughter. So the defendant was actually the sheriff, the elected sheriff in Letcher County, Kentucky. There are rumors that this thank you for putting it better than I could. We don't know exactly why he did it yet. The daughter thing was speculated, but it's also something about corruption and sexual of women in jail. There is a lawsuit. Let me go live and see. So that is the ex parte hearing is not going to be filmed, most likely. However, I do have this lawsuit right here. And I was reading it. I don't think I ever made it through it because it didn't sound like a lot of people were interested in this case at the time that I started reading this. However, that being said, I have about 1,000 more followers than I did back then. Ex parte is, well, usually an ex parte communication is like where someone sends something directly to somebody else. Like if Bruce were to email the judge, or anybody were to email the judge without going through like official channels in the docket, that would be an ex parte communication. What they're talking about in this ex parte hearing, I have absolutely no idea. I am not privy to that. I just found out about this hearing last minute, actually. But this was the complaint that was sent to me back in the day. I would say back in the day, like I want to say in like December. So Ben Field was and I can look more into this because this was Eastern District of Kentucky. So this was federal court. Ben Field's Sabrina Atkins was suing Ben Field individually and in his capacity as a deputy sheriff with Letcher County Sheriff, unknown supervisors of Ben Field, and Mickey Stines, the Letcher County Sheriff. This was like a smexy time for favors issue. It seems like the sheriff wasn't involved, but he knew what was going on and didn't take appropriate action. There is so many questions. If y'all want, we can have another stream sometimes where we actually go through this. Because I started to, I just don't ever think I finished it. And I will look more into what happened because this was filed back in 2022. So the day that the judge was unalived, they apparently had lunch together. So there is so many questions with this case that just do not make any sense. And I just can't, like here, defendant Fields made flirtatious comments about plaintiff's looks and bodies and told her that he was confident that they could work something out. There's just so many things that just, the more you find out about this, it's kind of another one of those rabbit holes that oh yes, the actual unaliving was on camera. I do have a whole Mickey Stines playlist. And in there we watch not only the body cam footage, but we watch the whole, yeah, that was before it was monetized, so I could show things, you know? So but it all happened, all of this that's alleged in this lawsuit. Defendant Fields took plaintiff into District Judge Mullins' chambers, telling plaintiff that he wanted to meet her there because there were no cameras. It's just a lot of And then between late June and December 2021, defendant Fields and plaintiff met at the Letcher County Courthouse in the evening or early morning hours approximately 6 times. During these meetings, defendant Fields' behavior escalated from flirtatious comments to, I'll let you read that for yourself, all of which occurred at the Letcher County Courthouse after hours in Judge Mullins' chambers. Plaintiff was coerced and compelled to comply with defendant Fields' advances given defendant Fields' position of power, and because she could not afford to pay for the ankle monitor and did not want to return to the Letcher County Jail. Plaintiff did not consent to some time. These meetings would typically occur the night before plaintiff had a court appearance, and defendant Fields would put plaintiff's ankle monitor back on and otherwise fix it so she would appear compliant with her home incarceration the following day. Upon information and belief in late December 2021, certain persons at the Letcher County Courthouse were notified that defendant Fields was having inappropriate communications and or relations with plaintiff and were provided text message evidencing the inappropriate communications and relations. I mean, plaintiff was arrested on January 26, 2022 in Pike County. Plaintiff is terrified that she will be transferred to Letcher County Jail, where upon information and belief, defendant Fields' wife is employed as an officer, and where upon information and belief, defendant Fields was previously employed. Upon information and belief, the Letcher County Sheriff knew or should have known that defendant Fields was SAing females, including plaintiff, in his charge. And that's where Mickey Stines comes into this. But like, what was his role? How much did he know? Did he actually know anything? Did he find out that people, including the judge, were one of the people that were essaying his daughter? Like, there's so many freaking questions. And this is the case where people are being tight-lipped. There's no people are speaking in the media. His lawyer did speak once and brought up this, but other than this case and this document right here, nothing else has been brought up. Nobody's talking about it. Like, it's mum's the word. It's just, so count one. Defendant Fields violated plaintiff's rights secured by the U.S. Constitution, Amendment 8 or 9, 4. My ability to speak today and read is interesting. Defendant Fields' wife, mother, cousin is employed as an officer. Also, defendant Fields' brother and father were the former prosecutor, and his cousin / uncle is the former mayor. I mean, that says Kentucky right there. I just, sometimes things just leave you speechless. And like, even though you have so much to say, you don't have the right words. Yeah, but with some of that, you're not wrong. That's the most Kentucky thing ever. Or Bama, depending on who you talk to. It's just, and I have to figure out what happened to this count 2. Another amendment violation. Count 3, deliberate indifference, failure to supervise and train, actionable pursuant to 42 U.S. Code 1993 against Letcher County Sheriff and unknown supervisors. It's Count 4, gross negligence, assault and battery against defendant Fields. It's so bad that, like, grossly negligent infliction of emotional distress. And it makes you wonder what all the judge knew and if that is why he did what he did, and or if he had a mental break. I don't know if it potentially. I don't necessarily disagree with the temporary insanity possible defense based on this other document. Mental disease or defect and mental condition bearing on the issue of guilt and punishment, based on the fact that he did it knowing that there was a camera and this was supposedly a friend of his. There's something that, and seeing the body cam, he does not seem like he is right in the head. I this right here. Yeah. Jeffrey, oh my goodness. Oh my goodness. Favor, please. If anyone hears the haters mention my name, please send me timestamps so I can continue to report them. I don't have the time to watch hours of their live shows. I haven't heard anything, but if I do, I will mention it to you. I don't watch their shows either, because, yeah. And that begs the question, which haters? Because I got a lot. You got the anti what the hales ecosystem, and then you got the people that are pro anti what or pro hales but still hate me. And you got the people that I don't talk to anymore because they got drama written all over them, and apparently that makes me evil. So you got to specify when you talk about the haters, because when you talk about hate, but you notice I was talking to someone yesterday, and they were like, "Well, your chat seems relatively, calm." And it's like, well, yeah, because I don't when the haters come in here, we make it a point to uh, uh, we make it a point to say hi. I am blissfully unaware of the what the hell's multiverse. I know a little bit, and what I do know is, like, I just don't, like, just leave me out of this crap. However, Dodgy Robbie, since he wanted to be dodgy, I do have his entire case from the Eastern District of Pennsylvania, where he was he did a year in prison, and we're going to investigate why he only got a year, but his co-conspirator got 18 months. Did he decide to be a bitch back then too, and throw somebody under the bus so he got less time? We shall see. But that is all I have for today, or for this one. I will be back in like an hour and 15 minutes for the other case. I just wanted to get this nice and out of the way. Unless y'all want me to go live early, and I can do that now. We can go straight over to the other other case. Rock and roll will never die. Let me go and redirect. And you know what? I can start that stream early, because that is what is fun. You'll try to be awake. I can go straight over there because it's actually better if I just do it now. I wasn't sure how long this hearing was going to be. And I also wasn't sure if I would have needed a break or not. So let me go to this and redirect everybody over to the other stream. And I will see you guys in a bit. I am going to take a potty break. Yeah, greatly appreciated. I'm reporting them for lying about me. Anytime, if you are on Discord, you can message me on Discord and I can see what people you're actually talking about, and I can ask anybody, because there's people who screen record stuff all the time, and send it to Jeremy, send it to various people. So I'm sure that if they know that you want your name looked out for, that if there's screenshots, there's definitely yeah. No, go be a mother, girlfriend. I actually prefer to get it out of the way because then it's done. Then it's done. So it'll be a squid raid on squid raid. Because then I can relax for the rest of my night. Because that was an hour. So, all right, I will see you guys on the other stream. Have a great afternoon if you're not hanging out with us over there. And I will see you guys in a bit. Bye.